Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Soto v. United States. In this case, the court considered this issue. When disabled combat veterans claim past due compensation, should the military use the CRSC statute's rules to calculate how far back they can be paid, or should it use the Barring Act's 6-year limit? The case was decided on June 12, 2025. The Supreme Court held that the statute that provides combat-related special compensation, CRSC, to disabled veterans establishes its own settlement process for claims, which supersedes the Barring Act's default 6-year statute of limitations for most claims against the federal government. Justice Clarence Thomas authored the unanimous opinion of the court. In the context of government claims, settling a claim means determining whether the claim is valid and, if so, computing the amount the claimant is owed. Congress does not need to use explicit wording such as the term settled to establish this authority. It is enough if, taken as a whole, the statute authorizes an agency to decide both whether a person is entitled to payment and how much payment is due. The CRSC statute gives the relevant military secretary the power to determine eligibility and the exact compensation owed based on statutory formulas. By establishing a comprehensive, self-contained scheme that charges the secretary with both validating claims and setting the payment amount, the statute creates a separate claim settling process. Because the CRSC statute authorizes the relevant officials to determine both entitlement and the amount of CRSC payments, the law functions as another law with its own settlement mechanism under the Barring Act. As a result, the default 6-year limitation period of the Barring Act does not apply to CRSC claims, regardless of whether the CRSC statute contains its own explicit time restriction. This ruling clarifies that Congress can displace default government claim procedures, including limitations periods, when it provides a comprehensive statutory process for resolving specific claims, as it did for CRSC benefits. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Thomas delivered the opinion of the court. Title 31 U.S.C. Section 3702, known as the Barring Act, establishes a default settlement regime for certain claims brought against the government. The Barring Act subjects most claims to a 6-year limitations period. But the Act includes an exception. If another law confers authority to settle a claim against the government, then that law displaces the Barring Act's settlement mechanism, including its limitations period, as to that claim. The question before us is whether a law providing combat-related special compensation, CRSC, to qualifying veterans confers authority to settle CRSC claims. We hold that it does, and thus that the settlement procedures and limitations established under the Barring Act do not apply to claims for CRSC payments. The Barring Act establishes default procedures for how a variety of claims of or against the United States government shall be settled. The term settle in this context refers to determining the amount of money a claimant is due. This meaning of settlement flows from the well-established principle that in the government claims context, when the government determines that a claim is valid, the claim should be paid in full. Thus, the inquiries relevant to settling a claim are straightforward. First, we ask whether the claim is valid, and second, if it is, we ask how much the government owes. The Barring Act authorizes certain entities to settle certain types of claims. Relevant here, the Act provides that the Secretary of Defense will settle claims involving uniformed service members' pay, allowances, travel, transportation, payments for unused accrued leave, retired pay, and survivor benefits. Most claims covered under the Barring Act are subject to a 6-year limitations period, but not all claims against the government fall within the Barring Act's ambit. While the Barring Act provides a default framework for settling and processing claims against the government, it includes a significant exception. If another law creates a separate settlement process, then that process displaces the Act's settlement mechanism. In 2002, Congress enacted the CRSC statute to provide special payments to military retirees who have suffered combat-related disabilities. Under federal law, retired veterans generally must waive a portion of their military retirement pay in order to receive disability benefits from the Department of Veterans Affairs, VA. But, under the CRSC statute, a retired veteran who establishes that his disability is attributable to a combat-related injury may receive special compensation up to the amount of waived retired pay. CRSC payments were initially limited to military retirees who, in addition to having suffered a combat-related disability, had served for at least 20 years. Congress later amended the statute to cover all combat-disabled retirees who are eligible for retired pay, effective January 1, 2008. The CRSC statute establishes a comprehensive framework for CRSC claims, governing everything from a claimant's initial application to the ultimate dispersal of payments. And, the statute confers upon the Secretary concerned authority to effect key determinations throughout this process. At the beginning of the CRSC claims process, the statute expressly requires the Secretary concerned to consider whether the applicant is eligible for CRSC payments. In other words, the Secretary concerned must confirm that the applicant is entitled to retired pay and has a combat-related disability. The statute defines a qualifying combat-related disability as one that is either attributable to an injury for which the member was awarded the Purple Heart, or that the claimant incurred in armed conflict, during hazardous service or conditions simulating war, or through an instrumentality of war. Disabilities that are not combat-related will not be considered in determining eligibility for CRSC or the amount of CRSC payable. Section 1413A separately establishes how to determine the monthly amount of CRSC payments to which an eligible claimant is entitled. Subsection B1 states that the monthly amount to be paid for any month is the amount of compensation to which the retiree is entitled under Title 38 for that month, determined without regard to any disability of the retiree that is not a combat-related disability. Subsection B2 sets a cap on the amount a claimant may receive, and subsection B3 provides specific rules to follow in the case of retirees who are retired under a separate chapter of Title 10. The CRSC statute does not include a statute of limitations or otherwise expressly limit the number of months for which an applicant may obtain payment. Corporal Simon Soto, petitioner here, served honorably in the United States Marine Corps from 2000 to 2006. During the first of his 2 tours of duty in Operation Iraqi Freedom, Soto served in mortuary affairs. In that role, Soto was assigned to search for, recover, and process the remains of war casualties. He struggled to adjust to civilian life following deployment and eventually received a diagnosis for post-traumatic stress disorder, PTSD, which his physicians attributed to his combat experiences. Soto was medically retired from the Marine Corps in 2006 and received numerous medals and commendations for his service. Soto later sought service-connected disability compensation from the Virginia. The VA ultimately assigned him a 100% disability rating for his PTSD, representing total occupational and social impairment, and awarded Soto disability compensation in June 2009. In June 2016, Soto submitted an application to the Navy seeking CRSC payments based on his combat-related PTSD. The Secretary of the Navy approved Soto for CRSC benefits in October 2016, and authorized him to receive retroactive compensation going back 6 years, to July 2010. The reason that Soto was eligible for only 6 years' worth of CRSC payments, the government explained, was that CRSC is subject to the Barring Act's 6-year statute of limitations. The following year, Soto filed a class action lawsuit in the United States District Court for the Southern District of Texas. He asserted that the Barring Act's 6-year limitations period does not apply to CRSC claims, and that he was therefore entitled to retroactive CRSC payments for the months dating back to January 1, 2008, the effective date of the statutory amendment that expanded CRSC eligibility to include combat-disabled medical retirees who, like him, had served for fewer than 20 years. After certifying a nationwide class consisting of former service members whose CRSC applications were granted, but whose amount of CRSC payment was limited by the Barring Act statute of limitations, the District Court entered summary judgment for the class. Because the CRSC statute defines eligibility for CRSC, helps explain the amount of benefits and instructs the Secretary of Defense to prescribe procedures and criteria for individuals to apply for CRSC, the court concluded that the statute constitutes another law that provides its own settlement mechanism, and so displaces the Barring Act settlement procedures. The Federal Circuit reversed. The court determined that Congress typically confers settlement authority by use of the term settle or other specific language. Absent such language, a statute cannot displace the Barring Act, unless another statute provides a specific provision setting out the period of recovery. The Federal Circuit thus concluded that the CRSC statute only establishes who may be eligible for CRSC payments, not how claimants can have those claims settled. Judge Reyna dissented. On his view, several of Section 1413A's provisions, including those that authorize the Secretary concerned to determine CRSC eligibility and the proper amount of payments, confirm that the statute establishes a process that meets the common understanding of settlement. We granted certiorari to decide whether the CRSC statute provides a settlement mechanism that displaces the default procedures and limitations set forth in the Barring Act. To decide whether the CRSC statute provides a settlement mechanism that displaces the Barring Act, we first address how this court has construed settlement of claims against the government and what is required for a statute to confer settlement authority. As both parties recognize, this court has made clear that the word settlement in connection with public transactions and accounts has been used from the beginning to describe administrative determination of the amount due. Simply put, The authority to settle a claim against the United States is the power both to determine upon the validity of the claim and to determine the amount due on it. A statute confers settlement authority so long as it vests an entity with the power to determine both a claim's validity and amount due. We have explained that, in the context of waiving sovereign immunity, Congress need not state its intent in any particular way, or use magic words to effectuate a waiver. That same principle applies here. While the most straightforward way to confer settlement authority may be to use the term settle, the presence of that word, or any other specific language, is not necessary. To decide whether a statute constitutes another law that displaces the Barring Act settlement procedures, we therefore look to the text, context, and structure of the entire statutory scheme at issue, and analyze whether the law confers authority to both determine a claim's validity and determine the amount due on the claim. The CRSC statute meets these requirements. At the outset, the law confers upon the Secretary concerned the authority to pay each eligible claimant a monthly amount that is determined under the terms of the statute. This grant of authority includes the power to determine both the validity of claims for CRSC payments and the amount due on each claim. Regarding validity, the CRSC statute provides that the Secretary concerned shall consider whether a CRSC applicant is an eligible combat-related disabled uniformed services retiree. Determining an applicant's eligibility requires the Secretary concerned to assess whether the applicant has followed the procedures and met the criteria established by the Secretary of Defense. Because the Secretary concerned shall pay CRSC payments to each eligible veteran, in this context determining a claimant's eligibility is tantamount to determining the validity of his claim. Thus, by charging the Secretary concerned to consider and evaluate each applicant's eligibility, the CRSC statute's plain text authorizes the Secretary to determine upon the validity of a claim for CRSC payments. The CRSC statute also confers to the Secretary concerned authority to administratively determine the amount due on an eligible veteran's claim. Subsection A instructs the Secretary to pay a specific monthly amount, determined under subsection B. Subsection B, in turn, details precisely how the Secretary will determine the monthly payments contemplated under subsection A, sets a maximum amount for these payments, and provides special rules that apply to CRSC payments for certain retirees. At bottom, Section 1413A establishes a self-contained, comprehensive compensation scheme for a narrowly defined group of exceptionally deserving claimants. Taken as a whole, the statute's unique combination of characteristics authorizes the Secretary concerned to determine both the validity of CRSC claims and the amount due on them. The statute thus creates a separate settlement mechanism, i.e., another law that displaces the Barring Act's default settlement procedures, including its limitations period. The Federal Circuit reached the opposite conclusion below by imposing undue requirements on Congress's ability to confer settlement authority and by disregarding the CRSC statute's plain language. The Federal Circuit reasoned that for a statute to provide settlement authority, Congress must use specific language that authorizes a government entity to settle a claim, which will typically be done by use of the term settle. Absent such language, the Court continued, a statute may authorize settlement only if it provides a specific provision setting out the period of recovery. We reject both premises. As this Court has repeatedly explained, Congress need not state its intent in any particular way, and we have never required that Congress use magic words. Thus, even if Congress typically confers the authority to settle claims by use of the term settle, that standard practice does not bind legislators to specific words or formulations. It is enough that a statute authorizes an entity to determine both the validity of a claim and the amount due on it. Nor must a settlement mechanism always feature a specific limitations period to fit within the Barring Act's another law exception. If a statute establishes a settlement mechanism and thus constitutes another law under Section 3702A, then it nullifies all of the Barring Act's procedures as to the alternative settlement mechanism, limitations period included. To be sure, Congress's choice to authorize the settlement of claims may often coincide with a statute of limitations, and we would not lightly assume that Congress wished to expose the government to unlimited liability. But where, as here, the statutory scheme involves a small group of particularly deserving claimants, it is not extraordinary to think that Congress wished to forego a limitations period. A settlement mechanism does not require a limitations period. Thus, so long as a statute confers authority to determine the validity of a claim and the amount due on it, the law displaces the Barring Act in its entirety irrespective of whether it separately addresses timing. Further, the CRSC statute clearly authorizes the Secretary concerned to determine CRSC claimants' eligibility according to specific criteria, and those criteria say nothing about time limits. Under these circumstances, the most reasonable inference is that the process of determining upon the validity of a CRSC claim simply does not involve applying a defined period of recovery. The Federal Circuit's focus on the absence of specific words and provisions led it to misinterpret the CRSC statute. On the Federal Circuit's view, because Section 1413A lacks specific language and its own limitations period, it establishes only who may be eligible for CRSC payments, not how claimants can have those claims settled. But that interpretation is belied by the provisions of the CRSC statute itself. The CRSC statute does not merely describe who may be eligible. It explicitly instructs potential claimants to apply to the Secretary concerned, and vests the Secretary with the authority to determine those applicants' eligibility. And, contrary to the Federal Circuit's assertion, the statute establishes exactly how the claims will be settled, again, by granting the Secretary authority to consider applicants' eligibility, and then prescribing how the Secretary will determine the amount due. The government's arguments for affirmance are no more persuasive. To start, the government agrees that a statute may authorize settlement without necessarily using the word settle, yet, echoing the Federal Circuit, insists that a statute still must feature hallmark formulations to confer settlement authority. Such hallmark formulations, the government tells us, include language that speaks of claims being allowed or disallowed, refers to a finding being final and conclusive, or designates authority to sue or be sued. But it is difficult to see how the government's hallmark formulations inquiry does not devolve into the same sort of magic words test that we have so often denounced. As with the Federal Circuit's demand for specific language and provisions, we reject the government's formulations' focused attempt to limit the ways that Congress may convey settlement authority. The government similarly reprises the Federal Circuit's assertion that the CRSC statute does not authorize settlement because it lacks any timing requirement, and further insists that our reading supplants the barring act's limitations period through Congress's silence. For the reasons we have already explained, we disagree with the proposition that a settlement mechanism must include a limitations period to displace the barring act, and the government's assertion that our interpretation permits the CRSC statute sub silentio to supplant the barring act misunderstands the CRSC statute. In enacting Section 1413A, Congress did not displace the barring act's limitations period through silence. Congress displaced the barring act's procedures and limitations by authorizing the Secretary concerned to determine the validity and amount due, and thus to settle, CRSC claims. The government also resists the conclusion that Section 1413A confers authority to determine the amount due on a claim for CRSC payments. According to the government, such a determination involves more than assessing whether the claim has merit or calculating what the claimant might be owed. It may also entail auditing the relevant account, making adjustments for any applicable debts or offsets, and effecting a final disposition. Because the CRSC statute does not explicitly assign this level of auditing and adjustment, the government suggests that it does not permit the Secretary concerned to determine the amount due, and thus cannot establish a mechanism for settling CRSC claims. This argument proves too much. The Barring Act indisputably confers settlement authority, yet it says nothing about audits or offsets. Instead, it simply authorizes the settlement of claims. The CRSC statute confers comparable settlement authority, and is likewise silent as to the extra accounting procedures that the government contemplates. We decline the government's invitation to read additional requirements into the administrative determination of the amount due. Finally, the government warns that if the CRSC statute creates an independent settlement mechanism, then every statute containing even one of Section 1413A's relevant features might also displace the Barring Act, and in turn destabilize various government programs. The conclusion does not follow the premise. In holding that the CRSC statute confers authority to settle claims for CRSC payments, we do not suggest that each singular component or subsection of the statute is independently sufficient to establish settlement authority. To the contrary, we hold only that Section 1413A's separate subsections, in combination, create a comprehensive CRSC benefits regime spanning from application to payment, and that, within this framework, Congress has authorized the Secretary concerned to determine both the validity of applicants' CRSC claims and the amount due on them. In all events, while we acknowledge that the Barring Act's limitations period plays an important role in managing the government's potential retroactive liability, we will not presume that any result consistent with the government's account of the statute's overarching goal must be the law. Even if we thought sound policy called for a narrower carve-out to the Barring Act's procedures than the other law exception that Congress enacted, that policy choice is a matter for Congress, not this Court, to resolve. The judgment of the Court of Appeals is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.